it's no crime to drive a vehicle. There was absolutely no information.
No, there is.
Court does call the case of the people state of Michigan versus Mario Cato.
Good morning, Your Honor. May it please the Honorable Court Jermaine Work P54352 on behalf of Mr. Cato, who stands to my immediate right.
Your name?
Mario Cato.
Thank you. Okay, what do we do?
This will be an exam, Your Honor.
Okay.
Yes, Your Honor. We will move to sequester any witnesses pursuant to People versus Lindsay.
All right. Witnesses are hereby ordered sequestered. The officer in charge may remain in the courtroom.
Thank you, Your Honor. The only person I have present in the courtroom is Trooper Crystal. He will be my one and only witness.
All right, very good.
And if I may call my first witness?
You may call him.
Thank you. Or you're calling me Trooper Crystal.
Sir, please come forward to be sworn.
Take a seat, raise your right hand. You solemnly swear to affirm the testimony you're about to give the whole truth and nothing but the truth, so help you God. Let her have a seat. State and spell your first and last name for the record, please.
Dustin Pietzel, it's T-U-S-T-I-N, last name Susan Charlie E-L.
May I inquire?
You may.
Thank you. First, I apologize for mispronouncing your last name. Thank you
Right,
I apologize. Thank you. Trooper, where are you currently employed?
with Michigan State Police on the Brighton Post,
In what capacity?
as Michigan State Trooper,
For how long have you been employed as such?
about 5 years.
Were you working in your capacity as a trooper on July 2nd to 2023?
Yes, I was.
On that date, were you working in the area of M14 in Superior Township, Washtenaw County, Michigan?
Yes,
What took you out to that location?
I was dispatched to a unknown crash, which turned out to be an injury rollover crash on M14 near Ford Road.
Approximately, if you recall, approximately what time of day was it when you were dispatched out there?
It was about 1900, so about 7 o'clock in the afternoon.
Thank you. Did you have the opportunity to arrive on scene?
Yes, I did.
When you arrived on scene, can you please describe for the court what you observed?
So when I was on scene, there was in the median of M14, there was a red Buick Regal that had severe disabling damage to it. The Superior Township Fire Department was on scene as well as HVA, and they were providing treatment to two occupants of the vehicle, one female and one male, who were both outside the vehicle at the time.
How far outside of the vehicle were they when you observed them?
Oh, I couldn't give you an exact distance, but they were a good ways away from the vehicle.
When you did you have the opportunity to make contact with both the male and the female?
On scene, no, because both of them were transported to the hospital by HVA, but I made contact with both of them at the hospital.
Let's talk about on scene. Did you have the opportunity to observe them on scene?
Yes, I did.
Let's talk about the male specifically. Was he transported to the hospital?
Yes, he was.
How was he transported to the hospital?
So he was still in a walking condition. He was able to be walked to the ambulance and escorted from there. He had some lacerations to his face and everything like that. He complained of had neck, chest pains from the crash.
Did you participate at all in helping him get medical treatment, calling HVA out or helping HVA in any way?
Like I said, pretty sure HVA was on scene.
Well, I'm
Prior
going to object to be speculating here.
He's answering my question based on his own.
Overruled.
Thank you, Your Honor. And the female, could you please describe for the court what you observed about her?
So she was in no condition to walk at all. Although I didn't talk to her while I was on scene because she was receiving treatment from HVA and the fire department, to me it looked like her right arm and right hip and leg did not look like they were in place.
I'm going to object to be speculating on that.
Well, no, he's saying what he observed. There's no speculation. Overruled. Go ahead.
Thank you. Could you please describe what you saw about her right arm that told you that it was not in place? What did you see?
You may.
Thank you. Trooper, that's the affidavit that I just asked you about, correct?
Yes.
And there's no mention of marijuana in that affidavit, correct? There's no mention of diabetes in that affidavit, correct? All right. You also didn't explore further Mr. Cato's other medical history besides his diabetes that could have caused this accident, did you?
I did not have a medical record for any of his prior medical history, so I did not know him.
All right, so you don't know if he had had a closed head injury or anything of that nature that would affect his cognitive abilities?
I did not.
Okay, thank you. And you had a conversation with the other occupant who was identified as Mr. Cato's girlfriend, correct?
Yes.
And in your conversation with her, she didn't mention anything about him using marijuana, did she?
He did not.
All right. In fact, in part of her conversation, she said they had driven all the way from Chicago, correct?
Sustain.
You also did not ask Mr. Cato whether or not he wanted an independent blood test, did you?
Whenever I read his chemical test rights, in the rights, he has the right to demand that a person's own choosing administer their own breath or urine test. So it was offered by Reynolds chemical test rights.
All right. Did you verbally tell him that?
When I read his chemical test rights.
Okay, very well. And you stated when you initially spoke to him, he was not under arrest, correct?
I advised him that he was under arrest, but that he would be left on scene for further treatment.
So how long did you speak with him before you said, during this initial period in which you stated he was not under arrest?
How long did I talk? I don't recall.
Okay. All right. And when was the decision made to place him under arrest?
After my conversation with him, when he admitted that he had been smoking marijuana during his car ride.
As you sit here today, you don't know whether or not he had a diabetic seizure that day, do you?
I do not.
Did you know that he actually had gastrointestinal distress before the accident?
Objection to speculation.
Sustain.
He may know, yeah.
Well, the phrasing of your question, I'm going to sustain it. You can rephrase it.
Okay. Do you know if he had any other medical conditions that caused this accident? Okay, thank you. No further questions, John.
All right. Any redirect? All right, thank you. Step down. Well, you can, Exhibit A is admitted. Thank you, sir. Any witnesses for the defense?
We have no witnesses, John, in this argument.
Do I have a motion?
Your Honor, this has a location behind with the information here.
All right.
We object to the buying over. We would submit that the affidavit for the search warrant that the officer submitted to obtain the client's blood rather than not comport with the law very specifically that requires probable cause for the search warrant. Specifically, there's no mention whatsoever in the search warrant, not only about my client being diabetic, but more importantly about there being any type of substance being involved in this case. There's no mention of THC. There's no mention of marijuana. There's no mention of alcohol. The case law, which is procedural in this matter, is People versus Courts. It comes out in the Michigan Court of Appeals, 1977 case that cited 75 Mich. App 415-254 Northwest 911, which basically states that an officer such as Trooper Pitchell secures a search warrant, more or less for probable cause, there has to be some indicia that a crime was committed. The only thing that search warrant mentions is the fact that my client was driving the vehicle.
But counsel, what do I do with the fact that it's because of his diabetic condition that they get the search warrant? But the trooper clearly testified that he consented to the blood draw in any event.
I understand it, but what I'm saying is that the actual search warrant itself is defective because of the affidavit.
Right, but he consented to have his blood drawn.
And I would even submit the consent is questionable under the circumstances under which my client found himself in. This very trooper even stated that my client wasn't even in a position to give a field sobriety test. He had
but
put into an ambulance, taken to a hospital emergency room. He's in a hospital bed.
that doesn't answer my question. My question is what do I do with his consent?
I would state that his consent was not valid under the circumstances, Your Honor.
What proof do I have of that?
Pardon?
I mean, I'd have to speculate that he wasn't in a position to consent. The trooper very clearly testified that he consented to the blood draw, but that because of his diabetic condition, he got the search warrant. What do I do with his consent? If I buy your argument from the get-go, but what do I do with his consent?
My position, Your Honor, is that his consent is not valid, considering the precarious medical position that he found.
All right, go ahead.
That's my argument.
All right, okay, if that's also the argument, while the search warrant may not contain that, he was placed under arrest is the trooper testified because there was an admission on his part to smoking marijuana during the car ride. What should I do with that? Even if I,
The same situation, my client wasn't in a position from the standpoint of his precarious medical position to consent to make any type of admission or consent clearly is violated of the case law which I'm citing, clearly violated of the Michigan Constitution, clearly violated of his constitutional rights on a federal level, and the case law that supports that as well. Yeah.
I don't know what I have that even gets me there, but okay, I hear your argument. Go ahead.
Thank you, Your Honor. I would ask Your Honor to look at the, not physically look, but legally consider the face of the search warrant within the search warrant probable cause. So when we look at paragraph B, this is the section of the search warrant that is about whether or not there is probable cause that the above named suspect was the operator of the vehicle. We have clear indication that this defendant was the operator of the vehicle. And in addition to that, the trooper actually went above and beyond not only to identify him as the person driving the vehicle, but also to articulate the driving that would be indicating to us that this person was impaired. The trooper wrote the defendant was traveling, that the witness told the defendant was traveling at a high rate of speed, that the vehicle started listing into the left shoulder from the left lane, that the vehicle then continually listed off the roadway into the median ditch, where the vehicle hit a median turnaround, causing the vehicle to go airborne and overturn multiple times. The front passenger was ejected from the vehicle and the driver was assisted out of the vehicle. Then when I look down at 3D, the probable cause that the above named subject was under the influence of alcohol or controlled substances. That information, that standard language in this form is included in this form because it's indicating to the court that this is an investigation for intoxication. We get to consider that standard language. And the facts that the trooper articulated was that the driver drove the vehicle off the left lane of the side of the roadway, causing the single vehicle to roll over in a crash. Both the driver and the passenger were severely injured. Passenger was ejected from the vehicle. We get to consider whether that type of driving would lead to probable cause that the driver of the vehicle was intoxicated. I submit to Your Honor that it does. Punishing the trooper for not putting information in the search warrant that he did not know at the time that he drafted the search warrant, that's not appropriate. But certainly, for also to go outside of the search warrant as well, I've argued that there is probable cause based on the search warrant alone. Trooper thank you, also testified that even after the search warrant is done, now for today's argument, that we learn additional facts. The defendant admits that he was driving while smoking marijuana. And so the search warrant itself is based in probable cause. And then for today's argument for bind over, we then get additional facts that lead further to probable cause for today's bind over. So Your Honor, again, at this point, I would ask Your Honor to bind over the information that's written.
If I may elaborate more, the case of People versus Courts that I cited earlier also mentions other case law, very specifically mentions that under a Michigan Constitution, blood alcohol tests are inadmissible under Article 2, Section 10 of the Michigan Constitution of 1908. I also cite the case of Unlawful versus Nikki, which is the Michigan Supreme Court case of 1958, 427-93 Northwest 2D 281. Basically, the public policy, there's the right of a security of a person under the Michigan Constitution. Level fines, exclusion of blood test results necessary under the Michigan Constitution, and quite frankly, may be even stricter than the federal standard. Even speaking to the federal standard, Your Honor, for a warrant to be validly issued, the investigating officers must offer sufficient information to support an independent judgment that probable cause does exist for the issue level warrant. The federal case cited there is Whitney versus Warden, U.S. Supreme Court case of 1971, 401 U.S. 564 Northwest SCT 1031. and also People versus Marshall, which was a 1976 Michigan Court of Appeals case. You don't have that here. This officer did not present sufficient information other than the fact that my client was driving a vehicle. It's no crime to drive a vehicle. There was absolutely no information.
No,
David.
but there is. Well, but there doesn't have to be specific information in the search warrant that would say this person is under a particular drug. I mean, if we were talking alcohol, certainly there would be certain indicia, but when people are ingesting controlled substances, we have something different, don't we?
Yeah, but there's no mention of that controlled substance.
How can he mention the controlled substance?
Well, even going greater than that, there's no mention in the affidavit of any crime whatsoever being committed to justify in that affidavit, John.
There doesn't have to be a crime, but counsel, what do you do then with paragraph 3C on the affidavit?
For probable cause, there does have to be a crime, Your Honor.
Probable cause to draw the blood?
Yes.
Okay. What do you do with paragraph 3C?
I would need to see it, Your Honor. I actually use my affidavit. That's what I referenced, Your Honor, about what the eyewitness said. The eyewitness says he saw an accident, Your Honor. He didn't say that he saw anyone consuming marijuana, under the influence of marijuana, or anything that relates to what my client is being charged with. Which is part of the reason that, quite frankly, on my cross-examination, I wanted to take up question about my client's medical conditions in terms of whether or not there's a diabetic seizure.
Yeah, but those are questions. They are not, that's not evidence before me. They're just questions, counsel. I mean, I have nothing, I mean, you could ask if he saw unicorns. That doesn't mean there were unicorns there. I mean, the cold-hearted reality is, unless I have something to base that on, it's something the trooper did not know. That's all it is. But I don't even know if that's true.
What the trooper said he did not know. That was part of his testimony. Yeah.
But he didn't know something that wasn't true, or didn't know something that isn't true.
That he did know something that wasn't true.
But I don't know that that's true. Your question that's my point. Your question just presupposes it. It doesn't tell me that that's true.
Our argument is that it's established that there's not problem.
I understand your argument. I'm just telling you, I don't have anything before me that says that. I don't have medical before me that says that there was a brain injury or anything else like that, or that there's a gastrointestinal problem. I don't have any of that other than the subject matter of your question, which I can't take to be true.
I would just ask that you take the officer's testimony. The officer's testimony speaks to that.
Anything else?
No, you don't.
Anything else in the table?
Your Honor, just very briefly, because I think Your Honor gets it. This radical driving, this extreme, is probable cause of intoxication.
Yes, and I would agree. I think there's nothing wrong with the affidavit, the search warrant. When looking at the four corners of the document, the specific challenge to the search warrant is that it doesn't mention a drug. Well, it would mention a drug. In fact, even when there is alcohol involved, it typically won't mention that there's alcohol unless the alcohol was found there. There may be certain other indicia that the trooper might observe, which is one of the reasons why there's check boxes. But I don't see anything deficient with the search warrant. I would also indicate that to the extent that one might find the trooper's testimony is that he could consent, that he consented to it. But that because of his diabetic condition, at least as disclosed by the defendant, that he opted for the search warrant. And So that creates another reason, but I don't see any reason to disallow the blood test result. It then becomes a question of fact as to the levels of the THC and or its derivative in the defendant's system, as to whether or not that caused the impairment or intoxication and then the impairment in the ability to operate the motor vehicle with regard to those levels, but also then the subsequent admission by the defendant that he had been smoking marijuana on the car ride also leads to or factors into whether or not the defendant was impaired at the time. There isn't and has been no dispute that there was a serious injury caused either to the defendant or to the passenger in the vehicle. So for those reasons, the court does believe that the people have indeed sustained their burden and would bind the defendant over to stand trial as charged. As to the Circuit Court Arraignment Council, you acknowledge receipt of the information.
Yes, Your Honor.
Defendant acknowledging receipt of the information. Does your client stand mute or how does your client plead at this
Yes,
time?
sir.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
June 4th at 1:30 before Judge Conti.
June 4th, 2024, 1:30. Pardon?
What was the judge's name?
Judge Conti.
Court does call the case, People versus Jawad Farhat.
Good afternoon, Your Honor. Ryan Murad, PA 3665, on behalf of Mr. Jawad Farhat, who stands present to my right. Sir, state your name for the record.
Jawad Farhat. All right. Counsel?
Judge, we've had the opportunity to review the pre-sentence investigation report. Today's the date and time set for sentencing. We have no additions, corrections, or deletions. We just look forward to allocution.
All right. Well, go ahead. Anything you want to say before I do impose sentence?
Absolutely, Judge. A bit about Mr. Farhat, some of his background. This is his first real non-traffic contact with the criminal justice system. He's not somebody who's usually behaves in the manner he's behaved in. I'm sure that the courts had an opportunity to review the description of the offense, see how high the BAC was. This is his first criminal conviction, and he's going to go through the ringer with probation, but he's already taken some significant steps that I'd like to highlight, including completing the victim's impact panel, including testing negative for any alcohol on bond. I think he's done a fantastic job with that regard. I've driven him to all of his court dates. I've known him since he was very young, and I can confidently tell you he's not driving. But what I can more confidently tell you is this isn't somebody who's going to be getting in trouble again. I've worked with his mother, I've worked with his father, his brother, his entire family's involved in this case. Everybody's upset with him, but I think he's mostly upset with himself. I've seen a ton of remorse since the arraignment to here we are at sentencing. His license has been suspended, his life's turned around. He's actually a bit more on his background, Judge. He was an undergrad when I was in law school. I went to high school with him. He was a freshman when I was a senior. So I kind of was an older brother figure to him, I'd like to think. Maybe a little bit let down, but I can tell you this was somebody who was enrolled in med school before. He's now, he's operating with his family company, doing pretty well. I'd ask the court to keep a few things in consideration. I know the recommendation is for.
Where did he go to school?
He went to Michigan State, Judge. Unfortunately,
I thought you said he went to school.
No,
I'm kidding. Go ahead.
He didn't get accepted into Maryland. Unfortunately, that was his first priority, but
said that.
they just, but his mom was born in Maryland, so he does have those ties. But wrapping this up, Judge, I mean, ultimately, I know that he's going to want to tell you a bit about himself too, but just to wrap this up, this is somebody who is going to be leaning into this terms and conditions, and he's already leaned into and knocked out a good chunk. I know he's prepared to pay his balance in full today. I'm going to ask the court to deviate slightly from the recommendations, Your Honor. In my knowing Mr. Farhat and seeing his progress on bond and what he's already done since his PSI, I'd ask the court to consider holding any AA classes in abeyance. I think this was surrounded by a poor choice, not necessarily a lifestyle. And additionally, I'd ask the court, Judge, to consider with regard to the testing. I know he's been doing really good on the SoberLink 3 times a day. Given how good he's done, I'd ask the court to maybe consider reducing the amount of that testing, or maybe instead of the SoberLink device, allowing him to test at maybe a local jams 1 to 2 times a month. Other than that, Judge, the only thing that I'm going to add here is he's actually proposing to his girlfriend, who's a physician in Florida. And he originally had a plan and to do this in Florida on May 9th or May 14th. So I'm also going to be asking if the court is considering allowing Mr. Farhat to travel and leave the state of Michigan for those days for that purpose. But that's everything I have to say.
9th to the 14th.
From May 9th to May 14th. He wanted to go to Florida and he plans on proposing.
It doesn't take that long to propose.
No,
Go ahead.
it doesn't.
Okay, anyway, go
We
ahead.
can maybe cut it short.
No, it's all right. Go ahead.
But that's all I have, Judge. I know Mr. Farhat has a few things he'd like to say.
Sir, what would you like to tell the court?
Well, first and foremost, I'd like to apologize to the city and as well as the court for my actions in November. Again, that is very out of my character. Of course, this was a poor mistake on myself. I would say it wasn't a lifestyle of mine, and I made the wrong decision. And honestly, I am living through the consequences day to day. For my work, I do have to travel a lot and having to pick up rides here and there, and people question me why and who and what. Try to kind of like, my family knows about it, but I don't want the entire company to know about it. So I've been struggling in that aspect. I have been really living through it 3 times a day. It was just Ramadan, so I would be staying up late, waking up a little late, but make sure I woke up in time to blow in time 3 times a day. There was a late infraction by 14 minutes, and I picked the phone and called Brian, my special agent, directly. I sent him a picture of where I was. It was at Eid dinner. And he told me, he's like, don't worry about it. Thank you. Like, you've been on time every single time we've done it so far. This is like your only freebie I'm giving you. And other than that, I just want to apologize and say that this is something that would never happen again. And I've hopefully learned from my consequences. It shouldn't have been made. I would like to apologize.
You're lucky to be alive. Plain and simple. Court does acknowledge this is not a serious misdemeanor as defined by statute, however, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient treatment, attendance at AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation and with a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. So therefore, the sentence of the court, you are placed on probation for a period of 12 months. You are to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $360 probation oversight fees. That is payable today.
Yes, Judge.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to testing as requested by probation. You are to complete the CCOP program or a comparable program. I am going to order at this time that you attend 2 AA meetings per week with monthly verification to probation. So I'm not going to change that. I'm going to order that given what I see in the report. You are to provide proof of the victim's impact panel attendance to probation that has been completed. I will continue the sober link for an additional 30 days in lieu of 4 days in jail. So that also I will not change, given that I would normally sentence you to time in incarceration. So I'm doing it that way instead. Below the 93 days in jail, credit 1 balance will be suspended. I will also order that defendant may travel to Florida May 9th through May 14th inclusive.
Thank you, Judge. With regard to one final condition, just so I'm 100% clear, after that 30 days testing of SoberLink, does that discontinue and then he just goes to random, or how does that necessarily?
It would then go to random testing as directed by probation. But it'll be on the SoberLink for that period of time.
Thank
Unless
you,
you
Judge.
want me to keep him on it.
No.
Okay,
I just wanted to be
I
clear.
didn't know.
Last,
I was trying to make you happy.
thank you, Judge. And the last thing I'll leave you with is if Mr. Farhat knocks this out of the park, like I know he's going to, are we able to file a motion at the halfway mark for early discharge?
Always able to file the motion. The question is whether or not I'll grant it.
I think you will, Judge. Thank you so much. You all have a great rest of the
We'll
day.
see. Let's call the case, people versus Raymond Smith.
Morning, Your Honor. Attorney John Freeman on behalf of Ray Smith via Zoom.
And good morning, Your Honor. Amy Reiser, appearing on behalf of the people.
Okay, Mr. Smith is present. All right. I think we were at a stage with this one. There were no witnesses that were going to be present by prior agreement. I was looking for an order. I think because of what I had done, I don't think that's been completed as of yet. So I'm presuming that I'll get one soon to sign.
Your Honor, I submitted some language to the prosecutor on Friday. I know that she's had an opportunity to review it. I don't think there's a meeting of the minds as of yet, as far as the language of the order. I feel that what I had submitted to them for consideration mirrored what the court stated on the record. I'm hoping that we, the attorneys, that is, can hammer something out. If not, my intention would be to submit what I believe is reflective of what the court directed the last time we were there, and leave it to the court to craft that language. There is a secondary issue as well.
Well, let's deal with the first issue. It seems to me that court was rather clear in terms of what was going to be a directive to YPD to supply a file to the court for in-camera review. I don't understand what the hangup in language would be.
The language in the order that speaks of a false accusation made by the victim, and I don't believe that determination has been made yet. So I don't think it's appropriate to put that language in the order indicating that the victim made a prior false accusation.
Your Honor, I'm prepared to entertain whatever language the people
Well,
would like.
just put allegedly in front of it. I mean, folks, I don't
Okay.
know that's what they're saying. I understand that people don't agree, and I don't know. So
I guess, and I wasn't privy to the last hearing my colleague
Okay.
covered for me, but I don't know why that language needs to be in there at all. If you're just ordering that that police investigation be released based on the arguments in court, I don't know why the term false accusation needs to be in the order at all. If the court is just simply ordering the release of the police report
well, their file.
or their file.
Yeah, right. I mean, I guess I don't know why it would need to be in there either. I was imagining, and I have not seen the order, that was sort of language that was sort of a preface to the order itself, but it's not, or what? Counsel, let's do this. Just submit an order to me. I thought you guys could draft it, but I'll just draft it and we'll be done. So we can get this thing moving.
I will do that, Your Honor, today.
Okay, so we're gonna need to put this out. You said there's another issue.
Yes, Your Honor. As part of discovery, we have been waiting for medical records from the people. Those medical records are directly related to the complainant. There has been an agreement among the parties that material will be disclosed. I don't know if the people have received it yet, but that is an outstanding discovery issue that we are still waiting on.
I spoke with Officer Rob, and he had the victim improperly sign the medical release. So when he turned it into the hospital, it was the wrong signature line. So he has to go back to the victim, have her sign it again. So he's working on that.
All right. All right. When do you want me to put this out to?
Your Honor, once we submit the order, we don't know how long YPD is going to take. So I would suggest setting it for another conference similar to this one at whatever point the court deems to be reasonable.
Set it for May 21st, and maybe.
Once we have the order, I can reach out to YPD to expedite it.
Good enough.
So May 21st will work. No witnesses still.
No witnesses.
May we do it via Zoom again, Your Honor?
Yes, as long as you guys, yes, you may do it. I won't say what I was going to say.
Thank you.
So, yes. All right. Thank you.
Thank you.
So the people versus Emmanuel Henry.
Assistant Prosecuting Attorney Morgan Burroughs on behalf of people.
Mike Gay, Assistant Public Defender on behalf of this.
Nope.
Okay, date time set for preliminary examination. Are we ready to proceed?
Your Honor, at this time, our complaining witness is not present, but I do have a forfeiture by wrongdoing motion. I am prepared to file today, so I would be requesting an adjournment to do so.
Response from,
Your Honor, we're here, it's the day set. Probably
pardon?
we're here, prepared to run the exam. I imagine, we're here, there's probably ample time for such a motion, prior to today. But, so I'll leave it to the court's discretion. I assume the people are prepared to start the exam anyway.
Your Honor, any motion filed prior today would have been premature because the victim would be required to not actually appear for preliminary examination.
What's the underlying basis of the motion?
Where the defendant explicitly told the victim that she was not to come to court to testify against him.
And that occurred?
That occurred back on April 6th. And for the record, I do want to note that that call has already been released to the public defender's office.
And how long will it take you to prepare your motion?
You want it in print?
You have it, you have it already. Mr. Gaddy, in terms of a response to the motion, how much time did you need?
I haven't got the motion yet or had a chance to look at it. I assume it's similar to others I've received. A week is, or 4 days is fine.
Well, let's see. Problem is my next preliminary exam date is the 21st, but I'd have to hear the motion before then. Date I can hear this motion. I can actually hear it on a PCC. Yeah, I'll just hear it on the hearing on the motion for wrongdoing by forfeiture. Today's 23rd. I'll hear that on May 9th, 2024 at 3 p.m.
Yes.
At 3 p.m. That's a Thursday. And then I will reset the preliminary examination in this matter for May 21st, 2024, 9 a.m. before me. Find good cause to adjourn given what's been placed on the record. And its bond will continue. Thank you.
Thank you.
Court does call the case, People versus Mohammed Farah.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Farha. Mr. Farha, please take.
Mohammed Farha.
Your Honor, Mr. Farha is before the court for a violation of probation hearing. Your Honor, Mr. Farha was sentenced in this case to a prosecutor deferred on March 13th. Since that time, Your Honor, he picked up 2 new felony cases, one with an alleged date of March 24th, 2024, the other with an offense date of April 9th, 2024. The first being a weapons carrying concealed, the second being a failed financial transaction device concealed without consent. He is being held in custody on those matters. At the time when he was arraigned on those, the magistrate did set a bond in this case of $625. At this point, Your Honor, probation's asking that we adjourn this violation hearing to May 22nd at 9 a.m. to determine the outcome of those pending cases and that his bond be continued. Given that there's not a conviction in place at this time, however, probation does have concerns of continued criminal behavior. Probation's asking that the bond stay as it is. And I'm not sure if the court can do this, but one of the conditions in his probation case with me is that he completes drug treatment. Is it possible that Mr. Farha start with the in-jail Dawn Farm program while he's sitting in custody with these pending felonies?
And if I get an order to that effect, I'll send it down and I'll see what they can do. I'm already treated.
If I send something to you?
Yes.
Okay.
Don Farm?
No, Ann Arbor Comprehensive Treatment Center.
But that's not in the jail, right?
No.
Your Honor, we have no objection to that recommendation.
All right. Given everything, I'll adjourn the violation of probation hearing to May 22nd, 2024 at 9 a.m. to look at the outcome of the pending cases. Bond will continue in this. Thank you.